Welcome, aspiring property professionals, to another critical deep dive in our ACE Your RES Exam Key Topic Deep Dive series.
Great to be here.
Picture this. You've put in the hours, you've found a dream property for your client, negotiated the best deal, and the option to purchase the OTP is signed.
Yep, the exciting part.
The ink is barely dry, and you're already envisioning, smooth sailing to completion, but then a curveball.
Always a but then, isn't there?
The vendor, the seller, suddenly can't, or worse, won't fulfill their side of the agreement. What now? Does your client's dream and all your hard work just evaporate?
Well, hopefully not.
Absolutely not. This is precisely why we're taking a deep dive today into a crucial, often stress-inducing, but ultimately empowering area for anyone in real estate. Understanding your rights as a purchaser when a vendor defaults on a property transaction. This isn't just theory for your RES exam, folks. This is absolutely foundational for your future career, for safeguarding your client's most significant investments, and truly for building your reputation as a knowledgeable and, well, reliable agent.
That's exactly right. Our mission in this deep dive is to try and cut through the legal complexities. They can often make these situations feel like an impassable jungle, can't they?
Definitely. Very intimidating.
We're here to extract the most important nuggets of knowledge, those aha moments that stick with you, and give you a clear roadmap of legal recourse.
Okay.
We'll explore core doctrines, practical strategies, and importantly, real-world case studies directly from Singapore's legal landscape.
Good.
By the end of this deep dive, you won't just be informed. You'll be, hopefully, well-prepared, ready to tackle these challenges with confidence, whether it's for your RES exam or for those real-life, high-stakes property transactions.
And trust us, we'll make this journey engaging, full of surprising facts, and just enough humor to keep you hooked, because learning about legal topics doesn't have to be as dry as old toast, right?
We can certainly try.
So let's roll up our sleeves and ensure you're ready for anything the exam or a property transaction throws at you. So you've helped your client view the property, you've negotiated the price down to the last dollar, and they finally secured that coveted option to purchase. A moment to celebrate.
Definitely a milestone.
But then, as you're poring over the fine print, you spot a clause that might make you pause the infamous "as is, where is."
Yes, that one.
What on earth does this seemingly innocuous phrase actually mean for your client or for you as a purchaser in the grand scheme of things? Let me share the typical wording, as you'll often encounter it in legal documents. The purchaser is treated as having notice of the actual state and condition of the property, and is deemed to have inspected the property, and no warranty or representation is given or to be implied as to the state, quality, fitness, or anything whatsoever, and accordingly the purchaser shall not be entitled to make or raise any objection or requisition whatsoever in respect thereof.
Wow, that's quite a mouthful.
It is, and it sounds pretty intimidating, doesn't it?
It certainly does, and it's a clause steeped in deep historical and legal tradition. This as is where is principle stems directly from an English legal doctrine known as caveat emptor.
Caveat emptor. Latin. Sounds serious.
It is. For those of us who didn't major in Latin, that translates quite simply to let the buyer beware.
Let the buyer beware. Okay.
What's truly fascinating here is that this ancient principle isn't just some dusty old phrase from a bygone era. It's a living, breathing cornerstone of Singapore law today.
Really? Still very relevant then.
Absolutely. It means the primary burden, and critically the risk, falls squarely on you, the buyer, to conduct thorough due diligence and all necessary checks before you decide to proceed with the transaction.
So the onus is really on the buyer's side.
Completely. So if a property is sold as is where is, it's essentially a legal disclaimer telling you, you get it in its current condition, flaws and all, whatever that condition happens to be.
Right. Warts and all, as they say.
Exactly. The legal effect of this is profoundly significant.
Yeah.
As the buyer, you are deemed by law to have inspected the property for any defects of quality and to have found it acceptable.
Deemed to have inspected, even if you haven't really looked under every rug.
Precisely. Even if, in reality, you haven't actually conducted a detailed, in-depth check yourself. It places a very heavy emphasis on pre-purchase vigilance, shifting the onus almost entirely to the buyer. This isn't just about the visible cracks in the wall. It's about the implied understanding that you've done your homework.
That's a powerful point. And the key insight for your practice as an aspiring RES agent is that as is where is isn't just a clause about the physical condition, it's a monumental shift of legal risk onto your client.
It really is.
It demands proactive and meticulous diligence from your client because the legal system assumes they've inspected, even if they haven't in detail.
The assumption is key.
So your role isn't just to help them find a property, but to ensure they understand the profound legal implications of this phrase. It's not just a fancy Latin phrase to impress at dinner parties. It's a stark reminder. Do your homework and do it thoroughly.
Absolutely. Or your client might find themselves owning a charming old home with a not-so-charming old plumbing system.
And legally, there's little recourse because they bought it as is.
Exactly.
Okay, so that's the as is clause. What about the time between signing the OTP and completion? That critical interval?
Yes. The limbo period.
All right, so you've navigated the as is where is clause, helped your client with their due diligence, and that option to purchase is officially signed. The initial excitement is buzzing.
Understandably so.
But here's a kicker, and it's a very common scenario. A few months could easily pass between the signing of that OTP and the actual completion of the property transaction.
Sometimes longer.
Now, what if, during this critical interval, that limbo period, the property decides to throw a surprise party of defects? Maybe the air conditioning unit suddenly gives up the ghost.
Or a pipe bursts.
Yeah. Or a section of the roof decides to take an unscheduled holiday, causing significant water damage. Can a buyer do anything if the property's condition deteriorates significantly after the OTP is signed? This is where things get really interesting, right?
It certainly does. This interval is indeed a crucial period, and the protection you have here hinges entirely on the terms explicitly stated in your option to purchase.
So it all comes back to the contract again.
Always. If your OTP includes a specific clause that imposes a continuing obligation on the seller to maintain the property's condition as it was on the OTP date, right up to completion,
Okay.
then you likely have clear recourse if there's material difference or a significant deterioration. That's your ideal scenario.
Right, that's what you want to see in the OTP.
However, and this is an important contrast to highlight, if such a clause is absent, that pervasive as is where is clause would generally compel you to accept the property in its state at completion,
Oh, dear.
even if it is significantly worsened since you first viewed it and signed that initial agreement.
Wow. So you could view a perfect place, sign, wait 3 months, and find a wreck, and still have to buy it.
Without that specific maintenance clause, potentially yes. It can be a very harsh reality for an unsuspecting buyer.
Thankfully, there's a widely adopted safety net in Singapore that's a true game changer for purchasers, reversing that default.
Yes, thankfully. This is really important.
Many standard form OTPs used today, especially for private properties, incorporate the Law Society's conditions of Sale 2020.
Very common now.
And here's the magic bullet. Condition 5.1 of these conditions states, verbatim, on completion, the vendor must deliver the property in the same state and condition as it was at the date of the option or the date of the contract, whichever is earlier, say for fair wear and tear, unless otherwise agreed to by the parties.
That's the key phrase right there.
This is your game changer, folks. The crucial insight here is that Condition 5.1 effectively reverses the as is where is default after the OTP date, placing a continuing burden on the seller to maintain the property.
Exactly. It shifts the responsibility back, at least for this period.
It's a vital shield for your client, and understanding it can prevent post-OTP nightmares. This means that if a material change or defect occurs, excluding only normal fair wear and tear, you can demand repairs or a price adjustment.
Right. And it's important to understand what fair wear and tear means.
Good point. What does it cover?
Think of it as the usual expected deterioration from normal living and occupancy, for instance. Minor scuffs on walls, worn paint, or a tired carpet that's just a bit older. Normal stuff.
Okay, the little things.
It definitely doesn't cover a burst pipe, a collapsed ceiling, or significant damage that wasn't there before. Those are material changes.
Got it. So Condition 5.1 is a big help, but you'd still recommend being proactive.
Absolutely. While Condition 5.1 is a robust safeguard, I'd strongly recommend a couple of proactive measures for your clients, the buyers.
Like what?
First, negotiate for a second inspection of the property, closer to the completion date.
A final checkup.
Exactly. Advise your clients to include a specific clause in the OTP that makes completion subject to this second, more detailed inspection.
Makes sense.
This provides a crucial opportunity to bring in contractors or experts for a thorough check. Depending on how the clause is worded, it can even give you the right to delay completion until the seller delivers the property in an acceptable condition.
That sounds like a powerful negotiating point.
It can be. It significantly reduces the chances of post-completion disputes. As an agent, this is a real value-add service you can guide your clients on during negotiation.
Okay, second inspection. What else?
Second, and this might seem obvious but is often overlooked, document everything.
Photos and videos.
Copious amounts. Encourage your clients to take loads of photos and videos during the initial inspections. Think of your smartphone as a legal shield.
Huh. I like that. A legal shield.
It creates strong, undeniable evidence for any legal proceedings if defects arise that weren't present or visible previously. These visual records can be incredibly powerful in proving your case.
So not just photos of the nice view, but photos of the plumbing under the sink.
Precisely. Advise clients to focus on specific fixtures, the operational status of appliances, and general structural integrity. Documenting what is working is just as important as documenting any existing minor issues.
So what's the practical implication here for you as an agent? Be savvy, be detailed, and wield your smartphone like a legal eagle.
You got it.
Documenting the property's condition with photos and videos is like having an instant replay button for any future disputes. It's a small effort upfront for potentially huge protection down the line, saving your clients significant heartache and money.
Well put.
Remember, for your RDS exam, understanding these conditions and proactive steps is absolutely critical for demonstrating your competence.
Definitely exam-worthy material.
All right, we've laid the groundwork, we've navigated the tricky interval between OTP and completion, but despite all the precautions we've discussed, sometimes the vendor just can't or won't follow through.
The dreaded breach of contract.
It's a broken promise. This is where things can get truly frustrating for your client. But fear not, because as a purchaser, you have a potent arsenal of legal tools at your disposal.
That's right, you're not powerless.
What exactly constitutes a vendor's default in a property transaction? And crucially, what are your options when that happens?
That's a critical question, and understanding a vendor's default is key to knowing your client's recourse. A vendor can be in default in a property transaction in several key ways.
Okay, let's break them down.
Firstly, and most directly, the seller might simply be unable or unwilling to sell the property under the contract.
Like they just changed their mind or get a better offer.
Exactly. This often happens if they find another buyer willing to pay a higher price, unfortunately, a common scenario in a rising market, where greed can sometimes override good faith.
Painful for the first buyer.
Very. Secondly, the seller might not be able to comply with the material term of the contract.
What kind of material term?
This could mean a failure to deliver vacant possession, meaning the property isn't empty and ready for your client to move in when it should be.
So tenants still living there, maybe?
Or the seller themselves hasn't moved out. Or it could be an inability to discharge a lien from the title, which means there's an outstanding debt or legal claim against the property that prevents a clean transfer of ownership.
Ooh, inheriting someone else's debt with the house.
You definitely don't want that. Thirdly, the seller might misrepresent a fact that was a warranty or representation within the contract itself, essentially misleading the buyer on a crucial aspect of the property.
Like lying about renovations.
For example, explicitly stating the roof was replaced last year when in fact it hasn't been touched in 2 decades. That's a misrepresentation if it was presented as a fact or warranty.
Gotcha. So unwillingness, inability to meet terms, or misrepresentation, are all breaches equal?
Good question. No, it's important to distinguish between minor and material breaches.
Oh.
For minor breaches, a small scratch on a wall, for instance, you, as the buyer, are generally expected to complete the purchase and then sue for any resulting damages.
So you still buy the house, but claim for the small repair cost?
Generally, yes. However, if a breach is significant, meaning it's a material breach, then you have a choice of more substantial remedies.
Ah, okay. And does it matter when the breach happens?
Yes, we can also classify breaches into 2 types based on timing. An actual breach, which is a clear failure to close on the agreed-upon closing date.
They just don't show up or transfer the property.
Right. Or an anticipatory breach, where the seller communicates their unwillingness to transfer the property before the closing date arrives.
They tell you in advance they're backing out.
Correct. Both types of breaches give rise to various legal remedies for the purchaser.
All right, so we know what a breach looks like. The vendor has dropped the ball. Now let's explore your legal toolkit, the remedies available to your client.
Let's do it.
Broadly speaking, we have common law remedies, which are mainly about money, and equitable remedies, which are more about making things right, sometimes literally forcing the sale to go through.
That's a good way to categorize them.
Let's start with the most common one, damages. Get ready to talk numbers and compensation.
Indeed. The primary common law remedy is damages. The purpose of damages is straightforward: to compensate the innocent party, which is your client, for the financial loss suffered due to the vendor's breach.
Make them whole again, financially speaking.
Exactly. To successfully claim damages, you, as the innocent party, must prove three things. One, that you suffered a financial loss. Two, that this loss was caused directly by the breach of contract. And three, that the loss claimed is not too remote, meaning it was a foreseeable consequence of the breach.
Okay, loss, causation, and not too remote, and you have to prove the amount.
Yes, you bear the burden of proving the quantum or the exact monetary amount of your loss.
Can you give an example in a property context?
Sure, think of it like this. If the seller fails to complete, and in the meantime, property prices have gone up significantly, your loss could be the difference in value, the cost of buying a similar property now versus the original contract price.
Ah, the lost opportunity cost.
Precisely. Or it could include the cost of finding an alternative property, any extra rental costs you incurred because you couldn't move in, maybe higher interest rates on a new loan if rates went up.
Things directly flowing from the breach.
Right. The not too remote aspect means the loss has to be something that a reasonable person would expect to happen as a result of that specific breach. If you claim you lost a major business deal because you were too stressed about the property falling through, that might be considered too remote unless the seller knew about the deal and its reliance on the property completion.
I see. What about those clauses sometimes put in contracts about damages?
You mean liquidated damages clauses? Yes, these are quite common. These are clauses where the parties agree on a fixed sum or a formula for calculating damages in advance should a specific breach occur.
Like, if the buyer defaults, the seller keeps the deposit as liquidated damages.
That's a classic example, yes. The benefits here are significant. If valid, these clauses relieve the innocent party from having to prove their actual loss in court.
So it offers certainty.
Yes, certainty and potentially substantial recovery without the need to actively mitigate loss. However, there are limitations. A liquidated damages clause is considered an unenforceable penalty if it is not a genuine pre-estimate of the loss that might actually be suffered.
So it can't be an excessive amount designed to just punish the other party.
Exactly. If a court finds it to be an invalid penalty, meaning the sum is clearly disproportionate to any conceivable actual loss, you'll still have to prove your actual loss the traditional way.
And the courts decide this.
Yes, the court will look at the substance of the clause, not just what it's called. Just because it says liquidated damages and not a penalty doesn't make it automatically valid.
Okay. What if you can't prove much financial loss, but there was definitely a breach?
In that situation, the court might award nominal damages. This is a small, often symbolic sum, like $1.
$1. What's the point?
It essentially acknowledges that a breach took place and establishes your legal rights, even without significant financial compensation. It's a legal victory, proving you were in the right, even if not a financial windfall.
Okay, I get it. Any other types of damages?
There's another interesting, though less common type called restitutionary damages. This shifts the focus from your loss to the gain the breaching party obtained through their breach.
So clawing back their profit from breaking the deal.
Potentially, yes. However, whether Singapore courts will consistently award this specifically for a breach of contract remains unclear and not straightforward. It's not a standard remedy.
Tricky one.
In such cases, you might instead pursue claims outside of contract law, like unjust enrichment, which is a legal principle preventing one party from unfairly benefiting at another's expense, even without a formal contract breach.
Okay, damages cover the money side. But what if your client had their heart absolutely set on that specific property, the unique view, the school zone?
Right. Sometimes money just isn't enough.
What if money simply isn't an adequate substitute for the unique home they envisioned? That's when we move beyond mere compensation and explore the make-it-happen tools in the equitable remedies arsenal.
Precisely. These are about fairness and justice beyond just monetary calculations.
Here's where it gets really interesting, because these remedies are designed to compel the performance of the contract itself, not just pay for the consequences of its failure. First up, among these equitable remedies, termination of the contract.
Right. Termination is a powerful self-help remedy. meaning the innocent party can take action themselves, though usually with legal advice.
Self-help, so you don't necessarily need a court order immediately.
Not to initiate the termination, no. It allows you to treat the contract as ended due to a breach. And once validly terminated, you no longer need to perform your obligations under that contract, like paying the balance purchase price.
When can you actually terminate?
The right to terminate typically arises in three main scenarios. Firstly, a repudiatory breach.
Repudiatory. Sounds serious.
It is. It occurs when a party, by their words or conduct, clearly shows an intention not to perform their contractual obligations.
Like the seller telling you flat out, I'm not selling to you anymore.
Exactly. Or deliberately making it impossible to perform, like bulldozing the house before completion.
Okay, maybe less dramatic, but damaging it significantly.
Yes. Or repeatedly failing to meet critical deadlines after formal notices have been served. It shows they don't intend to be bound by the contract.
Okay, repudiatory breach. What else?
Secondly, there's a right to terminate if there's a breach of an express condition explicitly written into the contract. The contract itself might specify the breach of this particular term gives the other party a right to terminate.
So, a pre-agreed deal breaker clause.
Essentially, yes. And thirdly, termination can occur if a breach of contract deprives the innocent party of substantially the whole benefit they intended to obtain from the contract.
So, the breach is so fundamental it ruins the whole point of the deal for them.
Correct. Think of it this way. Using an example from contract termination disputes. A landlord terminates a lease for alleged property damage, but the tenant argues the damage is within normal wear and tear. The key question is, was the damage truly a breach significant enough to justify ending the entire lease?
So, there's a judgment call involved.
Absolutely. And that's the critical limitation with termination. It requires careful judgment. There's always a risk of invalid termination, which could ironically put you, the party trying to terminate, in breach of contract if you get it wrong.
Ouch. So, self-help, but maybe get legal help first.
Very wise. While it's a self-help remedy, it's one best exercised with expert legal advice. Your role as an agent here is to advise clients on the seriousness of the breach and the potential ramifications of termination.
Okay. Beyond just ending the contract, sometimes you need the court to issue a direct order, a legal stop sign or a go sign, depending on the situation.
Yes, that's where injunctions come in.
Injunctions. These are incredibly useful for preventing further harm or compelling specific actions in property disputes, right? And they come in a couple of flavors.
Indeed. Injunctions are court orders that either forbid prohibitory injunctions or compel mandatory injunctions specific actions. They are a discretionary remedy, meaning the court decides whether to grant them based on the specific circumstances.
And there are different timings.
Yes, there are also different types based on timing. Interim injunctions are granted during legal proceedings to preserve the innocent party's position until a final resolution.
Like freezing the situation.
Exactly. For example, to prevent a seller from quickly offloading the property to someone else while your lawsuit is ongoing. This is crucial for maintaining the status quo.
So the property is still there if you eventually win the case.
That's the idea. Final injunctions, as the name suggests, are awarded at the conclusion of the entire legal action as part of the final judgment.
Okay, tell me more about prohibitory versus mandatory.
Prohibitory injunctions are the stop signs. They are often granted to restrain a prospective or further breach of a negative contractual covenant.
A negative covenant, like an agreement not to do something.
Correct. For example, if a seller has agreed not to sell to a third party before your transaction completes, a prohibitory injunction could prevent them from doing exactly that.
Makes sense. What if there's no specific "don't do this" clause?
If there isn't a clear prohibitory clause in the contract, you would typically need to show that the balance of convenience favors granting the injunction.
Balance of convenience.
Yes, the court weighs the potential, often irreparable harm to you if the injunction isn't granted, against the potential harm to the other party if it is granted. It's a careful balancing act, and the court tries to choose the path that causes the least injustice overall.
Okay, that's the stop order. What about the go order?
That's the mandatory injunction. These are the compel orders, and they are considered very exceptional discretionary remedies.
Why except?
Because they compel a positive act, such as forcing the seller to repair an omission or restore the property to a certain state. Courts are generally more reluctant to order someone to do something specific than to simply not do something.
I see. So they're harder to get.
Yes, they are only granted in special circumstances or where there is a high degree of assurance that it will be rightly granted after a full trial. The bar is higher.
Okay, so termination ends the deal. Injunctions control actions. But what about forcing the original deal?
Now you're talking about the ultimate remedy.
And now, for the remedy that most property purchasers dream of when a vendor pulls out of a deal, the legal equivalent of a mic drop, a judicial decree, specific performance.
The big one.
This is where the court literally forces the sale of the property to go through. It's the ultimate, you will sell this to me, power play.
Specific performance is indeed a powerful and highly sought-after remedy in property disputes, particularly for purchasers. However, it's crucial to understand that it is a discretionary remedy.
Discretionary, meaning not automatic.
Not at all. The court will only grant it if, under all the circumstances, it is just and equitable to do so.
Just and equitable.
And the primary consideration, this is a threshold requirement, is whether damages would be an adequate remedy.
Back to damages. So, if money can fix the problem,
Then specific performance is rarely granted. If the court finds that monetary compensation would fully and adequately make the innocent party whole, they'll usually just award damages. After all, the court's role is to provide justice, not necessarily to enforce every single clause of a contract, if another simpler remedy suffices.
but expert, you mentioned damages might be adequate. For many, especially here in Singapore, property feels inherently unique, a specific location, a specific layout.
That's a very common feeling.
Is it true that legally, land is often seen as irreplaceable, making damages a poor substitute? It's not like buying another bag of rice. You can't just replace one HDB flat with another identical one. They all have unique stacks, floors, views.
You've hit on a very important legal principle, and it's a common perception that has strong roots in law. The orthodox position in Singapore and many other common law jurisdictions is that land is indeed deemed to be unique and no substitute is adequate.
Seems unique. Okay.
This was strongly affirmed in cases like Wan Chi Song and another V Tan Boon Hua and another. Because of this inherent uniqueness, damages are typically considered inadequate, even for something as seemingly minor as a short-term commercial lease.
Even for a lease. Wow.
Yes, the idea is that no two plots of land, or even units within a building, are exactly alike in terms of location, view, size, facing, floor level, and other characteristics.
Can you give an example?
Sure. To illustrate this further, in the Wang Qi case, the purchasers weren't just buying any house. They specifically wanted a home conveniently located near a particular school for their child and close to their workplaces.
Right, specific personal reasons.
Exactly. This gave that specific property an intrinsic value beyond its mere monetary worth, a value that would be exceedingly difficult to quantify in terms of damages.
You can't easily put a price on that convenience or school proximity.
Precisely. The High Court, recognizing this unique confluence of factors, found specific performance to be a prima facie appropriate remedy in that instance.
So prima facie, like the default starting point for land.
Often, yes. For you as an agent, this means helping your client articulate why this specific property is irreplaceable for them. Is it proximity to a child's school, elderly parents, a unique view, or an accessibility feature that's hard to find? These details can strengthen their legal argument for uniqueness.
That's good advice. Make the uniqueness argument concrete.
However, while the uniqueness of land often makes specific performance a strong option, Singapore law has shown a more nuanced approach in recent years. It acknowledges that it's not always automatic.
Oh, so it's not a guaranteed win just because it's property.
Not absolutely guaranteed, no. The EC Investment Holding Teat Ltd v. Rideout Residence Pete Ltd case, for example, referenced a Canadian Supreme Court decision which suggested specific performance shouldn't be granted as a matter of course for land contracts without evidence of that actual uniqueness.
So you still need to show it's unique for your client's needs.
Exactly. The Singapore Court of Appeal, in its wisdom, acknowledged that discretion is the hallmark of equitable remedies like specific performance.
Discretion is key.
What this analysis means for you is that while land is often unique, it's not a rigid rule that guarantees specific performance. You still need to make a compelling, well-reasoned argument to the court for why monetary damages simply wouldn't suffice for your client in that particular situation. The court isn't just rubber stamping, it's genuinely exercising its discretion based on the facts.
So it's not a magical poof it's mine spell then, but a powerful, carefully considered legal command.
Well put.
I suppose there are situations where a court, even faced with the uniqueness of land, might still hesitate to grant specific performance. What factors might make a court refuse to compel the sale, even if a breach occurred and the land appears unique?
That's an excellent question, and it's important to understand the limitations. Because specific performance is an equitable and discretionary remedy, Several equitable defenses can be raised by the breaching party to persuade the court not to grant it.
Defenses against specific performance, like what?
One significant defense is substantial hardship. This is where ordering specific performance would cause disproportionate extreme hardship to the breaching party compared to the benefit for the innocent party.
Extreme hardship, like making them homeless.
That could be argued. In the Wang Qi-song case, for instance, the vendors argued that the bargain was unequal and unfair, and that they would be forced to give up their home without the financial resources to find another.
And did that work?
While the court did consider this hardship, it ultimately found the purchaser's conduct not egregious enough to deny the remedy. It demonstrates a high bar for this defense. It needs to be truly extreme and disproportionate hardship, not just inconvenience or financial disadvantage.
Okay, substantial hardship. What else?
Another defense is impossibility of performance. If the breaching party genuinely cannot perform the obligation, the court won't order them to do the impossible.
Like if the house burned down.
Exactly. If the property was completely destroyed by a natural disaster after the OTP but before completion, and insurance wouldn't fully cover rebuilding, compelling the sale might become genuinely impossible. The court would likely award damages instead.
Makes sense. Any others?
Delay, lashes, or unclean hands are also relevant. If the innocent party unduly delayed seeking the remedy, demonstrating a lack of diligence.
So you can't wait years and then demand specific performance.
Generally not, no. Or if the innocent party engaged in inequitable conduct themselves during the transaction, like misleading the seller in some way, the court might refuse specific performance, as equity requires you to come to court with clean hands.
Fair enough.
There's also public policy. For instance, courts are generally reluctant to enforce contracts that would lead to what's termed involuntary servitude, though this is far less common in property disputes. And finally, if the order would require extensive ongoing court supervision, imagine the court having to oversee every step of a complex property repair demanded under specific performance.
Right, the court doesn't want to become a project manager.
Precisely. They might decline and prefer to award damages instead to avoid becoming perpetually involved in managing a contentious transaction.
That makes a lot of sense. The courts want to ensure fairness and practicality. But what if the sale is tied to something outside the immediate party's control, like, say, HDB approval for an HDB flat?
The third-party consent issue? Very common.
Does that complicate compelling the sale, especially if the approval is withheld due to the vendor's issues rather than the buyer's?
That's an excellent point, and it often arises in HDB transactions where a third-party authority's consent is crucial. When third-party consent is necessary, such as HDB's approval, courts generally won't order something that literally cannot be done.
You can't force HDB's hand.
Exactly. You can't force HDB to approve a sale if it doesn't meet their criteria. However, there's a crucial distinction here. If a contractual obligation is itself conditional on obtaining a third party's consent, then any specific performance order will likely be conditional as well.
Conditional on getting the approval.
Yes, but, and this is key, the court can compel the defendant, the breaching vendor, to take all necessary steps within their power to try and obtain that consent.
So they can force the vendor to cooperate with HDB.
Precisely. They can't force the outcome from HDB, but they can force the action from the vendor filling out forms, paying fees, resolving their own outstanding issues with HDB that might be blocking the approval.
Is there a case example for this?
The Wang Qi-xiang case again provides a powerful illustration. In that scenario, the HDB could not proceed with the sale due to the vendor's outstanding payments and failure to comply with HDB's rules.
So the vendors were the roadblock.
Yes. The High Court, despite this hurdle, granted specific performance. They didn't just order the sale, they ordered the defendant vendors to appoint lawyers and take all necessary steps to complete the transaction, including settling their HDB arrears.
Wow, quite specific orders.
Furthermore, and this is truly remarkable, they empowered the Registrar of the Supreme Court to act on the defendant's behalf if the defendant failed to comply.
So the court could step in and sign things if needed?
Effectively, yes, to ensure the process moved forward. This demonstrates the court's ability to facilitate completion and overcome third-party hurdles by actively compelling the breaching party to fulfill their part in the process of seeking that external consent.
That really shows the power and flexibility of specific performance, even with external factors.
It ensures that no stone is left unturned in working towards the original agreement. It's a powerful example of the court's reach when it deems it just and equitable.
Okay, we've covered the foundational concepts and the heavy-hitting legal remedies. Now, let's pull it all together with some real-world scenarios, legal twists, and crucial exam-ready takeaways.
Let's do it. These are the situations that can really test your understanding.
These are the kinds of situations that can stump even experienced agents.
Indeed. These scenarios often trip up aspiring professionals. First, let's consider a common but very challenging situation: a vendor's financial predicament or bankruptcy.
The money problems scenario.
We've seen real-world queries on platforms like renotalk.com where a purchaser asked, "Can I sue him to sell the property instead?" when the HDB owner was declared bankrupt and claimed to have no money.
Right. Can you get specific performance from a bankrupt seller?
This highlights a critical practical limitation. Even if you have strong legal grounds for specific performance or substantial damages, actually enforcing these against a bankrupt party or one with no assets can be incredibly challenging, lengthy, and expensive.
So you might win in court, but get nothing.
It's a real risk. The official assignee steps in during bankruptcy, and secured creditors usually get paid first. An unsecured buyer might be left with very little, even with a court order. It's not just about winning the lawsuit, it's about recovering anything meaningful.
That's sobering.
As an agent, advising your client on the enforceability of a remedy is just as important as knowing the remedy itself. Sometimes the best legal advice might be to cut losses and walk away, even if you're legally right, because the cost and uncertainty of fighting aren't worth the potential recovery.
That really highlights the human element, doesn't it? Beyond the legal remedies, the emotional toll on a client whose dream home falls through due to factors entirely outside their control can be immense.
Absolutely. It underscores why our advice as agents, guiding them through these potential pitfalls, is so crucial from the very beginning.
This next one is a fantastic example of legal trickery, and it's a real eye-opener that shows courts can see through the smoke and mirrors.
Ah, the disguised transaction. Always interesting.
Sometimes what looks like a straightforward property sale on paper is, in reality, something entirely different, designed to perhaps skirt regulations or achieve another purpose. So what's the deep dive insight here for due diligence and understanding the true nature of a deal?
This brings us to the fascinating EC Investment Holding Pleat Ltd v. Red Out Residence Pete Ltd case from 2011. The facts here are key. ECI, a property developer, wanted to buy a property. Ridout, through its representative Anwar, was in severe financial distress and desperately needed a loan.
Okay, a seller needing cash urgently.
They entered into an agreement that was structured as an option to purchase, with ECI paying a significant option fee of $1.5 million.
A big option fee.
Crucially, the agreement included a clause allowing the owner, Ridout, to cancel the option by paying a higher sum of $1.68 million within 60 days.
Wait, the seller pays more to cancel than the option fee received? That sounds odd for a sale.
Exactly, that was the crux. The dispute arose when ECI treated this as a genuine sale, and when Ridout couldn't cancel by repaying, ECI sought specific performance to force the sale.
But Ridout argued.
Ridout argued it was a disguised loan. They claimed the $1.5 million option fee was the loan principal, and the $1.68 million cancellation fee was actually the principal plus a very high interest payment, disguised to look like a property transaction.
Wow. So using an OTP structure to hide a high-interest loan.
That was the argument. The Singapore Court of Appeal, in its judgment, looked beyond the mere labels of option agreement and sale and purchase. Citing an earlier case, City Hardware, they focused on the true nature and substance of the transaction based on the entire factual matrix.
So digging underneath the document labels.
Yes, looking at oral evidence, contemporaneous documents, the parties' behavior, to determine their actual common intention. The court emphasized that if a document is a disguise, the true intent will prevail.
What were the clues it was a loan?
Several key indicators emerged. Anwar consistently intended to obtain a loan, not sell the property. ECI's primary concern during negotiations seemed to be Anwar's ability to repay the $1.68 million cancellation fee, rather than focusing on the property's purchase price itself.
Their focus was on getting the money back plus profit.
It seemed so. Also, ECI conducted a litigation search on Anwar personally, Ridout's sole shareholder director. This only made sense if ECI was acting as a lender concerned about the borrower's creditworthiness. A director's personal litigation history is generally irrelevant if you're just buying property from their company.
Good point. Any other signs?
Yes. Anwar's later complaints to the police explicitly described the transaction as money lending, with a high interest rate, and ECI trying to make more money out of the deal. The transaction also lacked traditional features of a sale, like how profit would be handled if ECI resold the property quickly.
So the pieces pointed towards a loan structure.
The outcome was pivotal. The judge found it was, in fact, a disguised loan with security, the property acting as collateral. This finding was critical because it meant ECI was legally a lender, not a purchaser.
And that changes everything for remedies.
Drastically. The court would not grant specific performance of what was essentially a loan agreement dressed up as a property sale. ECI's rights were those of a lender, not a buyer wanting that specific property.
Wow, that EC investment holding case is a fantastic aha moment. It really shows that courts prioritize the reality of the deal over its superficial appearance.
Absolutely. Substance over form.
It's a huge lesson for due diligence, reminding us all that we need to look past the surface and understand the true intentions behind transactions. As an agent, this means being acutely aware of any unusual terms or structures that don't quite fit a standard property sale. Your spidey senses should be tingling.
If something smells fishy, probably is.
This kind of insight is invaluable for your RES exam, showing you understand the deeper legal principles. Let's consider another common real-world challenge. What if a vendor genuinely wants to sell but discovers a massive, previously hidden structural defect in the property after the OTP is signed, maybe during preparations for handover, and the cost of repair is astronomical?
Ah, the nasty surprise scenario.
They might then want to back out, claiming it's too expensive to fix. How does Condition 5.1 play into this, and what's the agent's role here?
That's a classic tricky situation. If Condition 5.1 of the Law Society's Conditions of Sale 2020 is incorporated, the vendor is obliged to deliver the property in the same condition as at the OTP date, save for fair wear and tear.
And a massive structural defect is definitely not fair wear and tear.
Not at all. So technically, the purchaser could insist on specific performance, demanding that the vendor repair the defect before completion, regardless of the cost.
But the vendor might argue hardship.
Exactly. The vendor might argue extreme hardship, perhaps claiming the repair cost would bankrupt them. A court would then have to weigh the vendor's hardship against the purchaser's contractual right to receive the property as agreed. It becomes a balancing act.
So, what should an agent do in that situation?
As an agent, your role is crucial here. Encourage clear communication above all else. Facilitate getting independent estimates for the repairs so everyone understands the true cost involved.
Get the facts straight.
Yes. Sometimes the parties might then negotiate a solution, perhaps a significant price reduction, instead of the vendor doing the repairs, allowing the buyer to manage it post-completion. Or, if the situation is truly untenable for both sides, they might even mutually agree to terminate the contract, perhaps with the vendor refunding the deposit and maybe some agreed costs.
Find a practical way out.
It's about finding a practical, commercially sensible solution, often with guidance from both parties' lawyers. Your role is to facilitate that difficult conversation calmly and professionally.
Okay, bringing it all together then. What crucial lessons should our listeners carry forward from this deep dive, especially for their RES exam and their future career?
Right, the key takeaways.
Mm-hmm.
Firstly, clarity in contracts is paramount.
We keep coming back to the contract.
Because it's foundational. As seen in sources discussing contract termination disputes, ambiguous clauses like unsatisfactory performance without a clear, objective definition are just breeding grounds for disagreements.
Leads to arguments later.
Exactly. Every single term, especially those regarding conditions, obligations, and termination rights, must be precise, leaving no room for misinterpretation. This protects everyone involved.
So as an agent, review carefully, question vague language.
Yes, and advise clients to ensure their lawyer drafts or reviews everything thoroughly. Don't let ambiguity slide.
Okay, clarity's number one. What's next?
Secondly, understand the power of the notice to complete. In property contracts, time is rarely automatically of the essence, unless the contract explicitly says so.
Meaning deadlines aren't always super strict?
Not unless they are made strict. If a party is delaying completion, simply letting the date pass might not be enough to terminate or claim major damages immediately. You often need to make time of the essence.
How do you do that?
By serving a formal notice to complete. The Lim Alaik v. Surrender Singh case clearly illustrated this. Even after several extensions for completion were granted, the vendor's solicitors still needed to issue a clear, formal notice to complete, specifically invoking the relevant condition in the Law Society's Conditions of Sale, like Condition 29 then, to make time strictly binding.
So it's a formal step to say, okay, deadline is now really the deadline.
Precisely. This formal notice signals to the other party that any further delay beyond the new date specified in the notice will be considered a breach of a fundamental term, giving rise to serious remedies like termination and forfeiture of deposit.
And what about giving extensions after serving the notice?
It's also vital to note that extensions given after a notice to complete has been served should ideally be granted without prejudice to the rights under that notice. This preserves your ability to act on the notice if the extended deadline is also missed.
So, flexibility without losing your rights.
Exactly. For you, an agent's understanding of this notice procedure can be crucial in managing client expectations about delays and ensuring deadlines are taken seriously when needed.
Okay, clear contracts, understand the notice to complete. What's the final takeaway?
And finally, a perennial truth that cannot be overstated. Seek legal advice early.
Always the lawyer.
Always. Given the sheer complexity and the significant financial stakes involved in property transactions, we're talking about people's homes, major investments, you, as an aspiring agent, must always, always, always recommend that your clients seek legal advice from a qualified conveyancing lawyer at the earliest stages of any property transaction.
Not just when problems arise.
Definitely not. Get them involved from the OTP stage, or even before. This proactive step can prevent significant heartache, protracted disputes, and immense financial loss down the road. It's an investment, not an expense.
And it's good professional practice for an agent.
Absolutely. It's
Yeah.
a hallmark of professional, ethical agency. Protect your client by ensuring they have proper legal guidance.
Well, we've certainly delved deep into the labyrinthine yet utterly fascinating world of purchasers' rights when property vendors fail to fulfill their end of the bargain.
It's a complex area for sure.
You've really covered some crucial ground today that's directly applicable to real-world challenges and, of course, your upcoming RES exam.
We truly have. To reiterate the core insights for everyone listening, understanding the as is where is clause, and, critically, the robust protections offered by the Law Society's Conditions of Sale 2020 are foundational.
Know the baseline and the safety net.
Exactly. Knowing your options, from damages to termination to the powerful remedy of specific performance and the nuances of each, is paramount. Remember, damages need proof. Termination needs valid grounds. Specific performance is discretionary.
Right.
Be vigilant for complex scenarios like vendor bankruptcy, which can complicate recovery even if you win legally, or the tricky disguised loan, where the true nature of a deal can be hidden behind legal jargon. Always look deeper.
Substance over form again.
And above all, always champion clarity in contracts and advocate for early legal counsel for your clients. It's the best protection.
These aren't just academic points from a textbook. They are vital, practical knowledge for safeguarding your client's most important investments and, of course, for acing your RES exam.
They really are.
Being the agent who truly understands these legal protections and can guide clients through such treacherous waters makes all the difference in this competitive industry. It's about being truly well-informed, adding real value.
The property market in Singapore is dynamic, and understanding these key legal principles, knowing your client's rights, and anticipating potential pitfalls will give you a significant advantage. Remember, knowledge is truly your most powerful tool in real estate.
Absolutely. So armed with this comprehensive knowledge, go forth with confidence. Study hard, understand these scenarios, and remember the importance of diligent, well-informed advice. We wish you all the very best of luck in your upcoming RES exam.
Yes, best of luck, everyone.
You've got this.